All right, so welcome from my side as well. So it's a great pleasure for me to introduce Orla, not because I'm an expert in law and legal aspects myself, but actually because I'm really not. And the KASTEL Distinguished Lecture Series is sort of something where I'm expecting that we are hearing something new, and this particular is true for me. So I and a lot of colleagues of mine in KASTEL are doing very technical stuff. We do have a few strains that are concerned with legal aspects. And since we are trying to combine these different research fields, having a talk by Orla is a very good opportunity for us to actually achieve exactly this. So Orla is an associate professor at the London School of Economics, and she's doing this since 2012. And as a matter of fact, she's the third speaker from a London institution in a row. So this is really just a coincidence. I'm promising we're not pursuing a secret agenda here on getting every expert from London over here to Karlsruhe. Before that, she has earned a bachelor's degree from the Trinity College in Dublin and a master's from the College of Europe in Belgium, Bruges. And a PhD from Cambridge, actually. So just by touching from the CV, this already shows us that we have an expert here on legal aspects in the domain of EU regulations of different technologies. And yes, without further ado, I would say the stage is all yours, and we are looking very much forward to the talk.
Turn this on. Thank you very much, Chris, for that very generous introduction. I'll have to say the distinguished in the title for the series is a little bit intimidating, but hopefully we'll manage to have a nice conversation this afternoon. So thank you to all of the members of the KASTEL team for inviting me. It's a real pleasure to be here. And maybe what Chris lacks in legal knowledge, I would say I lack in technical knowledge. And so hopefully we'll find a way to kind of meet halfway today. So what I want to talk about is synthetic data or artificial data and its legal implications. And so here specifically, I want to look at the way in which substituting real data with synthetic or artificial data will potentially allow you to fake it until you make it, if my slides would work. Let's see here. Thank you. When I said I wasn't technical, I did assume I could work PowerPoint. But so this is a co-authored work in progress with Professor Michal Gal, who's currently a visiting professor at NYU Law School. And so we wanted to look at the ways in which synthetic data changed relationships that are legally governed. And we looked at different types of relationships. So we looked at relationships between competitors, so the ways in which it might potentially change competitive dynamics on a market, and then also the ways in which it might change the relationship between users of synthetic data and those that are affected by synthetic data use. And our hypothesis was that if it changed these kind of power dynamics between competitors on the one hand and those who use synthetic data and broader society, then our legal framework, which is based on the assumption that we use real data, might need recalibration to adjust to this new synthetic data reality. So there's been very little legal work done on this so far. We were really starting from first principles, and a lot of the literature that we've been working off is industry literature. And so the claims made might be overstated, and you can help me to identify where the overstated claims are, or overly broad or potentially ambitious. And so The backdrop for this work is the idea that we are increasingly recognize that data is an essential input in digital markets and in digital society. So states are increasingly using data in administrative decision-making, for instance, in the allocation of things like welfare benefits. But equally, we've seen a lot of attention in recent years to the possession or control over data and the extent to which that can be a source of market power. And so, given this kind of increased value of data, there's a disparity, I guess, between data supply and data demand, where demand for data is outstripping the supply or the availability of data. And this is where synthetic data claims to have a role to play. So the argument is that if there isn't sufficient real data available, then perhaps we'll be able to fill that gap by generating synthetic data that would act as a reliable substitute for real-world data in certain instances. And so it was the legal implications of that claim that we wanted to examine and evaluate in our paper. So what do I mean by synthetic data here? Well, keeping it very simple, as a lawyer, I would say by synthetic data, we mean artificially generated data that still retains analytical value. And by that, I mean that it retains or mimics the original properties of the real data set by maintaining the distributions between various features and the distributions between various values in the real data set. And so if a real data set is reliably synthesized, then you should be able to reach the same inferences or conclusions based on the synthetic data set as you would the real data set. And so in that sense, they would be substitutable from a utility perspective, or close to substitutable from a utility perspective. So we're looking at synthetic data generated using learning models. And for our purposes, in terms of legal relevance, we differentiated between three different types of synthetic data generation models, let's say. So the first is where no real data is used, and where based on the assumptions of an analyst or prior knowledge of an analyst, assumptions determine a model or are used to create a model, which in turn is used to generate synthetic data. And so this might be a case of kind of transfer learning, where you're incorporating inferred knowledge from another kind of domain, let's say knowledge that you gain by watching passers-by on a street, and that you combine with some textbook knowledge about who is likely to be passing a street at a certain point in the day. So you're not actually collecting any real-world data, but based on observations or other learnings, you generate a synthetic data set on that basis. So here there will be no real data or personal data used in the generation of a synthetic data set. For the other two types of models that we looked at, real data is used in the synthetic data generation process, either as input, where you input synthetic data into a generator and input real data rather into a generator, you generate synthetic data, and then that synthetic data set is refined by discriminating or by comparing to another real data set in an iterative way until you end up with a data set that mimics or resembles the original input data. Or you might have a data set where no real data is used as input, but we're simply comparing the synthetic data generated by the generator with real data in a discriminator and refining the data set again in an iterative way so that it resembles the real world data. So you will be far more familiar with the technicalities of this than I will, but I think from a legal perspective, we might just differentiate between the kind of blue box where no real data is used to generate the synthetic data set. And then the other models where real data is being used to either refine or as input to create the synthetic data set. And so when we were looking at the legal implications of this, we classified these into 3 pillars. And these pillars were based on the claims that we found in the industry materials about the benefits of synthetic data. And so I think it's possible to assess the implications of synthetic data in terms of data access and the legal framework around data access, in terms of data privacy, which is where the majority of the focus has been so far, and also in terms of data quality. So how does synthetic data kind of change these various factors around data? Well, in terms of data access, the claim made by synthetic data proponents is that it increases availability or access to data. And the examples given are, for instance, in situations where real-world data is very rare, so something like fraud in the case of banking, then in order to generate data or to have some data around those kind of outlier instances, then you might generate some synthetic data to kind of plug into a data set to make it more representative of those rare cases. So banks are apparently using synthetic data at the moment to generate these kind of instances of fraud. Equally, we could imagine situations where there are physical or other impediments to the collection of real-world data. So the ongoing pandemic is probably a very good example of this. So companies like Google, through its ride-sharing app Waymo, during the pandemic, when it was impossible to gain real-world or gather sufficient real-world data about those using the ride-sharing app, generated synthetic data in its stead. And so again, the idea was to provide a substitute to real data where it was too difficult to obtain. And then finally, perhaps most controversially, you could say that synthetic data might provide access to data in places where the law imposes constraints on data availability. And so here you might think, for instance, of information that is protected perhaps by intellectual property. But more obviously here, I would think of situations, for instance, where a legal framework like data protection law imposes constraints on data sharing. So in data protection law, we have a principle of purpose limitation, where data collected for one purpose cannot be used for another incompatible purpose. And so here the argument goes, well, if you use synthetic data instead of real data, then arguably, as we'll talk about, some data protection laws won't apply, and this will allow for increased kind of data sharing. And again, some banks in the UK and elsewhere have been using synthetic data to kind of justify broader data sharing internally and externally using synthetic data. So we change kind of data access conditions. I've already mentioned data privacy or data protection. So most obviously, we could look at synthetic data as a type of anonymization technique or a security technique, perhaps that adds an extra layer of protection to data by kind of obfuscating individuals in the data set. But equally, proponents say that synthetic data enhances data minimization. So again, data protection law contains a legal principle that you should only process, so that could include gathering or further using the minimum amount of data necessary for your purposes. And so the claim is that with synthetic data, if you simply generate it with a specific purpose in mind, you can kind of have a bespoke data set for a specific purpose, and that can enhance data minimization or promote data minimization under the law. And then finally, again, the claim is made that synthetic data improves the data privacy utility trade-off. So the argument here is that because synthetic data sets, if done well or appropriately, mimic the statistical properties of a real data set, they would kind of maintain to the best extent possible the utility of the real data set while adding this additional layer of privacy. But as we'll talk about, one of the ways in which kind of privacy is enhanced in this context is by saying, well, the data is anonymous, and that is something that we might contest from a legal perspective. So question mark over whether or not it does in fact have this potential to enhance the privacy utility trade-off. And then finally, the last set of claims concern data quality. And here, the claim is that if a data set is skewed for whatever reason, it might be that it underrepresents some populations, for instance, women in management roles, or overrepresents some populations, as we see when algorithmic profiling is used in criminal justice contexts in order to inform where the police actually use their resources. You might have an overrepresentation of some communities in a data set as a result. The argument goes that synthetic data can help to improve those class imbalances by adding more data from the underrepresented data group into the data set. And so in this way, it can help to deal with issues of kind of bias in data sets. And so again, we're kind of in the realm of looking for a technical solution to deal with potentially biased algorithmic outputs where the input data being used to train an algorithm is itself kind of skewed. And so this might fall under the legal principle of data quality, which I'll talk about. So they're the industry claims of what synthetic data would do in an ideal world and what it would change. So what implications does this have for the law? Well, if we turn first to data access, over the past, I would say 5 or 6 years, we've seen in Germany and elsewhere an increased emphasis from lawmakers and from regulators on the role of data in contributing to the market power of certain big tech companies. And so, for example, the OECD, the Organization for Economic Cooperation and Development, which has a kind of a high-level policy role for competition globally, has said that data can contribute to the strengthening of the market position of certain players and the durability of that market position. And the idea here really is that the companies that already possess a large amount of data will have a kind of an uncontestable market position, and that data will act as a barrier to entry for new companies to come and to compete with those incumbent operators. And so here, synthetic data could potentially change that situation in a number of ways. So first of all, for companies that have kind of only small data sets at the moment, they have the possibility of potentially augmenting those data sets or adding to those data sets in a way that helps them to be more competitive. This might also then do things like limit the benefits of so-called cross-market network effects. So a company like Google, for example, is in a position of kind of paramount significance, according to the German law. Why? Because it operates across various markets. So you could think its role in Fitbit, its role in search, its role in content provision through YouTube, and that it's able to gather data from all of these various sources, this variety of sources. And if it aggregates that data, then this gives it a competitive advantage that it's difficult for others to replicate. Well, One claim that is made is that synthetic data might be able to kind of limit the benefits of that kind of cross-market data aggregation, because you might be able to generate replica data that would give other companies the same benefits. It might also, because you could generate synthetic data that might kind of rival real data, it might increase the incentives to actually share real data, because the benefits of hoarding that data to yourself as a company are limited because there is alternative data available. And that might even kind of lower the cost of that type of data, because the cost will be capped effectively at the cost of the creation of synthetic data. And then finally, you might say that where data access and data gathering has a kind of a collective action problem, because some individuals won't, for instance, allow their data to be collected because they object or there's no legal basis to do so under data protection law, then this can mean that it can be hard for data sets to be as complete or as representative or to scale in an appropriate way to make them useful. So you might think of something like health data in the context of a health service. If only 50% of people sign up to giving their health data for research purposes, then that data set will lose utility, and you might have a kind of a collective action problem. So again, here the argument goes, well, you could bypass that collective action problem by using synthetic data to fill the gaps in any resulting data set. And so what we examine is this idea that maybe enabling the generation of data changes market dynamics in these various ways, or has the potential to change market dynamics in these various ways. And we query whether or not then this has implications for the law. And we identify two ways in which this might be relevant. So first, it might affect the need for laws to apply. So the need for regulatory intervention in some circumstances. So an example of that is that if you look at new EU legislation, so adopted very recently and which will enter into force in May, we have this Digital Markets Act, which applies to so-called gatekeepers. So these are the kind of the big tech companies. And they're defined in a slightly more sophisticated way, but in essence, it's big tech regulation. And it applies different legal obligations to actors with gatekeeper power, this power to control markets over those that don't have gatekeeper power. And one of the obligations that you find in Section 6 of that Act is a kind of a data sharing obligation. So there's an obligation on the gatekeeper platforms to share their data with business users in real time in a way that is effective and with good quality data, in order to try to reduce the asymmetry of power in terms of the possession of data between big tech and smaller enterprises. If synthetic data could potentially replace real data in some circumstances, then the justification for this kind of mandatory data sharing in the law, which assumes that data is an essential facility that people need to be able to access in order to be able to compete, might change. Equally, when we're looking at things, findings under existing market laws like competition law, this might affect, for instance, a finding of monopoly power. So if we consider a company as a monopoly because they possess a lot of data, well, if you could replicate substitute data, then we might say they're no longer in a stable monopoly position. And, similarly for mergers. I won't go into the details, but maybe one query I would have here is that these kind of potentially positive effects for data availability on the market would depend on the extent to which the possession of real data is a necessary prerequisite for the generation of useful synthetic data. So it might be that synthetic data completely changes the competitive fabric of the technology market as it is now, but it might also be, on the other hand, that it simply consolidates the existing positions of power of some of the big tech actors if they're able to leverage the data that they already have in order to generate more data. And so I think this would be a technical and an empirical question to see to what extent existing real data sets would confer that kind of competitive advantage on the companies that already hold them, and therefore whether or not these competitive changes will come about. Okay, so that's kind of legal change one, is around data access. The second kind of big pillar of change will be around data privacy. And so here, this is a quote from the Harvard Business Review, sponsored content, mind you, but still, which says that, well, you can read it, with the GDPR in the EU and the CCPA, which is the Californian Data Protection Act, and other privacy regulations around the world, making sharing of personal information so complicated, if not impossible, synthetic data is vital to support collaboration. As it is fully anonymous, it is exempt from these rules. So the argument goes, synthetic data equals anonymous data and legal rules do not apply. Well, as no doubt you can imagine, not so fast. So here, what does the law in Europe have to say about this? Well, if you look at the GDPR, you see that it defines personal information or personal data as any information that relates to someone who is identified or identifiable. And a natural person just means, a human rather than a legal person, a company. So we could query then, how does this definition apply to the type of data that we were talking about generating, where we were either using real data as an input or real data as a comparator in order to kind of benchmark or to refine the resulting data set? Where you use real data in that way is the output, the synthetic data that is produced, is it itself personal data? And I think here you might say, well, obviously, this is a silly question. If you can still identify somebody in the data, then it won't be anonymous and it will be personal data. To that, I say yes, but there are still a number of legal ambiguities that I would like to kind of bring to your attention. So first of all, what do we mean by identifiability? And here I think there's a bit of a disconnect, or at least not a perfect symmetry, between the legal conditions for identifiability and those that you find, from a more computer science perspective. So legally, you might kind of query, well, an individual is identifiable if it is possible using means that are reasonably likely to be used to identify that person. So this begs a lot of questions. What are means that are reasonably likely to be used? How do we determine what a means reasonably likely to be used is? What is a tolerable risk of identification? Is it zero risk? Is it a 50% risk? We have a very good legal article highlighting the various ways in which national regulators across European countries have interpreted this in different ways. So I would say it's certainly not zero risk, but the body of European data protection authorities in Europe suggested in an opinion, which is now quite old, that it was zero risk. That opinion is currently being revised, so we wait to see what the outcome of that will be. And then also identifiable from whose perspective. So in the UK, for example, the law is currently under review. So we have a new act before Parliament because we're availing of our Brexit freedoms. And that law says that we're looking at this from the perspective of the entity that is holding the data. So it's a subjective perspective. But of course, that's nonsensical, because once anybody else gets access to that data, then it can easily be combined with other data potentially, and an individual is easily re-identifiable perhaps on the basis of that data set. So it doesn't look like a particularly reliable way of defining what is identifiability. At EU level, we know that the Court of Justice has said identifiability from the perspective of the data controller or a third party. Is this any third party globally? Or is it, again, a third party into whose hands this information is reasonably likely to kind of fall? Open questions. And so when I looked at more technical literature on this, noting I didn't go too far into technical literature, the criteria look a bit different. What's the risk of singling out? What's the risk of inference? What's the risk of linkage? These are the different types of risks that are discussed. And just to say, in some of the only empirical work that seems to be done on this so far by Therese Stadler and Carmela Troncoso and others, their claim is actually that the anonymization or the protection provided by synthetic data is quite poor because it doesn't protect the original records from linkage and kind of attribute inference in the original data set, amongst other things. So we have this big open question about identifiability. But even before that, I think we have a question, which is often overlooked even in the legal literature, about what it means to be identified. So here, and this was recently pointed out in a brilliant article by Nadia Portova in the Netherlands, we might assume very different things, or the standard will be very different if we think to be identified is to be identified in terms of your civil identity, compared to be identified is to be individuated or singled out, or even more broadly, treated differently to other people. So we had an interesting conversation earlier about Google's proposals for advertising and its proposal to kind of group individuals into categories or cohorts in order to offer ads on the basis of those cohorts. So in advertising, it has never been in the interests or needs of advertisers to know your civil identity. And so they're introducing more and more measures to make it less likely that your civil identity will be known. But those measures still enable them to differentiate between you and others in other cohorts and even within the cohort. So what does it mean to be identified for the law? Is it civil identity, in which case all of this targeted advertising will fall outside scope of the GDPR and the definition of personal data? Or is it individuated, where we could mean being singled out here? And I wonder then also, and this is a big step into the unknown, does it matter who is identified? And so here I'm starting to think about the idea of horizontal data relations. So if a synthetic data set, if my data, my personal data, is used as an input or as a comparator for a synthetic data set, then that data set might be linked back to me as an identified person. But what if my data is used to create a synthetic data set, which is then used to make an inference about Philip? Sorry, Philip, I shouldn't identify you in a privacy lecture, but about a third party, let's call him P. And so the information about me is used to make a decision about P. So P was never in the original data set. Can that data set ever identify him? Well, if we mean his civil identity, it can't be traced back to the synthetic data set, but you might say, or the input data rather, or the comparator data. But maybe at the point at which the inference is made about P, let's say that he's trustworthy as an employee, then does that become personal data about him as an identified person? It's unclear whether or not the law requires a kind of a direct connection between the individual whose data was used to make the inference and the individual about whom an inference is made. And so we're starting to see these kind of increasing, what I would call, or what has been called by Salome Villeon in the States, indirect or horizontal data relations. And this becomes even more tricky Because, in this example, P, if he is treated as a trustworthy employee or a good employee, would be perhaps not known by civil identity, but would be individuated or differentiated based on the data, and so potentially identified. But what about when you apply insights derived from my data to a group? There, you're treating a group in a particular way. This group is going to get products offered at this price, and this other group is going to get products offered at a lower price. There's no singling out there as such. We're kind of categorizing. Does the concept of personal data capture that type of categorizing? Again, I would say it's unclear. And so we have these kind of big questions about not only whether or not you can be identified or you are identifiable on the basis of a synthetic data set, but also more fundamentally, what it means to be identified. And then finally, if I haven't lost you, the last element of the definition of personal data, because keeping in mind it's information, so let's assume that covers everything, though you might disagree, that relates to an identified or identifiable person. What does it mean to relate to somebody? Again, this is totally underexplored in the legal literature. The guidance says information relates to somebody if it's about them. Okay, but is a synthetic data set generated using in part my data about me? Clear nods here, but the advisory body says it's about you when the content is about you, and it seems to refer more to direct identifiers than to kind of any kind of indirect identification. So even if data isn't about you, it can be relating to you by reason of its purpose or effect. So this means when it's applied to an individual. And so this suggests that the same data set, where all of the direct identifiers are stripped out, might meet the threshold for personal data when it's applied directly to individuals. But before that point, before it kind of bites and has an impact on individuals, it would not. And so here, what are the implications of that? Well, that means until the information relates to somebody, you might be able to use it without any data protection principles applying. You could use it, I guess, on the plus side for training and testing and other things. But this starts to make things very, very complicated, because it means that a data set can kind of shift throughout its life cycle from being personal to non-personal data, depending on how it's being applied in practice. So this is completely underexplored in the literature so far, and the case law that we have relates to, pardon the pun, pretty obvious situations. So does an exam script relate to an individual and to the examiner? Well, yes, because the information stemmed from them and it has impacts on them. But this doesn't tell us about how we apply this criteria more broadly. So here I see data protection law at a bit of a crossroads. So if we say that we interpret this term personal data broadly, and we apply it whenever it impacts on an individuated individual or impacts on an individual that has been singled out, then that could be any data. That could be any data that you take, that you use, that impacts on an individual, becomes personal data. And so some people would say, well, we're no longer concerned with the personal data here. It hasn't come from the individual. It's not somebody's information being wielded in a way that harms their fundamental rights. It's a third party's information being wielded in a way that harms their fundamental rights. And so there might be a query here about whether this kind of fits with the origins of data protection law and whether this gives it an overly broad scope. So that's kind of taking data protection in one way. The other way you take it is you say, well, yes, any information Once it is applied to an identified individual, and we interpret identified broadly as somebody who's impacted or singled out by information, then that information becomes personal data. So a colleague here in Karlsruhe, Dara Hallinan, has written a very nice short provocation on the idea of personal data protection without personal data. And the argument here would go, well, we look to the purposes or the objectives of the law. And if the purposes or objectives of the law was to protect people from information and induced harms, then what does it matter whether the harm stems from information that originates from them or a third party or, dare I say, artificial data, as long as there is that kind of informational harm? And so here you would address more data-induced harms. So these, I think, are the pathways that we could see data protection go down. But to go down either of these paths, we need courts to start thinking about these issues a little bit more carefully. Okay, the last point I want to make then, I'll skip that and potentially come back to it, is around data quality. So we said we've data access implications, data privacy implications, data quality implications. And so from a data quality perspective, the law deals with data quality in various different ways. So data quality is a long-standing principle of data protection law. So here you can see the OECD version, which says that personal data should be relevant to the purposes for which they are used, and to the extent necessary for those purposes should be accurate, complete, and up to date. In the EU's proposed AI Act, which applies irrespective of whether or not the data is personal data or non-personal data, so this applies to all data sets for AI, you see that it has a specific provision on data quality also. So Article 10.3 says that training, validation, and testing data sets shall be relevant, representative, free of errors, and complete, which is potentially an impossible standard, right? But synthetic data might help you get you there. And so this, in some ways, is the law acting as an incentive for the market to help to render data sets more complete, more representative, etc., etc. Now, when you look into the recitals of that law, so like the detail of the law, it's representative, to the extent necessary for the purposes. So this isn't an absolute obligation of complete data, but it's complete to the extent necessary for those purposes. And so we're kind of looking at data quality then as something that is good, or data completeness, data accuracy is something that is good. Again, from a legal perspective and from a fundamental rights perspective, I don't see this as completely unambiguous. So first of all, if we treat these kind of technical fixes as a solution for bias or discrimination, obviously they alone are not going to be an appropriate response. And so you could say here, well, where you use real data in order to create a synthetic data set, if the real data set is itself skewed or biased, then the synthetic data set, if it mirrors its statistical properties, will also be skewed or biased. So it doesn't kind of magic away those problems. We also have a situation where a lot of bias creeps in, not through the training data, but through the way in which the output of an algorithmic decision or automated decision is interpreted or applied. And of course, this does nothing, this tinkers at the edges of kind of structural discrimination in society, by simply looking at it from this kind of narrow technical perspective. So I don't see it as a catch-all to deal with kind of bias or discrimination, needless to say. But there are also kind of other challenges, I think, that follow from complete data sets. So the more complete, the more granular the data set, the more transparent it renders those who are kind of represented in the data set. And so this can kind of change asymmetries of power between those who possess data and those who have decisions made about them using that data. And so Ji-Hong Chen, a British scholar, talks about the loss of maneuver space that this gives to individuals, because individuals are increasingly still rendered transparent by data, and this might be exacerbated the more accurate, the more complete the data. This granular data potentially allows for new forms of categorization and discrimination, but also, I think quite interestingly, if one of the claims is that you can use synthetic data in order to fill gaps in data sets, for instance, where an individual withholds consent through data protection law, then we are effectively using synthetic data to bypass the individual's wishes in relation to their data in a way that circumvents the legal framework. So we might be using the technology to override individual or maybe even societal preferences about what data should be available in a given context. And so again, if that were the case, and I'm not saying it's going to happen today or tomorrow, but if that were the case, we would need to fundamentally rethink the ways in which, for instance, data protection law gives individuals control over their data, because that control will be so easily circumvented if you could generate a replicate data set from which the same kind of statistical learning could happen, irrespective of what the individual does with their data. And so this isn't simply a synthetic data problem. This is already a kind of a challenge in data governance, but I think synthetic data has the potential to exacerbate this in some ways. So just wrapping up then, what we see is that there's a potential here to kind of change the balance between rights and interests that we see presented or consolidated or found in our existing data governance laws, because we're kind of changing the power dynamics here between competitors and between individuals and those who process personal data. And so this might, in some instances, require us to kind of recalibrate some of our existing data governance and legal frameworks. But also, I think synthetic data is a useful lens through which to illuminate or to view some of the current challenges that we have anyway in data governance law. So should data protection law apply to inferences based on, horizontal third-party data or synthetic data? Is this the right remit of the law? Are we concerned with information-induced harms or protecting data, very fundamentally? In what circumstances should the law place hard limits on accuracy? For instance, if we look at financial services law, there are limits on the types of information that a bank can take into account when assessing your creditworthiness. If we have this kind of data abundance, do we need to think about other areas in the law? And a European scholar, Aileen Nielsen, has written about this, where we think about accuracy bounding, limiting the accuracy, blurring the edges of the accuracy of automated output in certain circumstances, because a too accurate algorithm might be harmful. And then more generally, synthetic data is kind of working off the proposition that more data is always good, and that more data will generate more efficiencies. And in some ways, this sits in tension with ideas that we find in human rights law, like data minimization. And so this is, I think, a very fundamental tension that we see between, for instance, competition regulators when they're talking about data. So duplicating the data, making more data available to more entities, whereas the normative direction, the thrust of data protection is trying to bring you in another way. Placing certain limits on data sharing, placing limits on data creation in some contexts. And so at some point, we'll probably need to have a more political discussion about whether we want to sacrifice some of the efficiencies of data in order to protect rights. And synthetic data, again, I think, places emphasis on that. So that is everything I want to say today, but I'm looking forward to your questions.